Welcome back to Canadian Justice, where we're discussing the Myles Sanderson case, parole, statutory release, and dangerous offenders. Howard, in the last segment, you were walking through how the process of how people get out of prison. You were talking about day parole, and what I think people need to understand, what I led off in the last segment, is that Mr. Sanderson was released on something called statutory release. Now, what do people need to know about that process?
Sure. So statutory release is the third form of conditional release, and statutory release happens, as the name implies, statutorily. So the law is written in such a way that people who didn't qualify for day parole, didn't qualify for full parole, or perhaps had been released and were revoked, were now in prison for a fixed period of their sentence. Again, because of the evidence that this works, this is best for public safety, they will be released statutorily, typically with much more severe restrictions or conditions on their freedom. And so SR, or statutory release, is sort of the end point. So as people are serving the last final portion of their sentence, they'll be released in the community. Again, maybe with a residency condition to a halfway house, certainly with reporting conditions to a parole officer. And even in the introduction, Christine, when you talked about the parole board finding that somebody was not a danger to the public, typically the way the decisions are made is that the person has risks, but they can be managed with these conditions. So with the reporting frequency, with the geographic restrictions, with the non-association restrictions, etc. So I don't think anybody's ever released with zero risk. But it's about managing that risk in appropriate ways to keep people safe.
So I want to get Ari in here. Ari, is there anything you want to add about the statutory release, how that works, and anything you want to add about how it might have applied in the Sanderson case?
Sure. Very briefly, I think a lot of people watching us won't know the numbers here. Let's use a 9-year sentence, for example, when they hear warrant expiry, statutory release. Let's use 9 years as a sentence. You read a headline, somebody bad got 9 years. They can get full parole after a third, 3 years. Statutory release is the 6-year mark. The warrant expiry that Mr. Sapers spoke about was 9 years, where sort of like the Shawshank Redemption, the gates of prison open and out you go. When you get to statutory release, there's this mindset in the correction services that most people are going to get out, even if the evidence shows that they are a ticking time bomb. You almost have to look Paul Bernardo like to be held until warrant expiry. But there are mechanisms that prosecutors and police forces can bring, even when somebody gets towards the end of their sentences. That's not done. And remember, and I'll end my answer here, he was in the wind, Myles Sanderson. So let's remember that he was in the wind, AWOL, unlawfully at large, so to speak. And the police force, in an outspoken way, said, we didn't know where he was, and we weren't looking for him. And there are hundreds, if not thousands, of people in each province like that. If that doesn't set up a public safety problem, I don't know what does.
Yeah, not super reassuring to hear that. Let's talk about that Paul Bernardo example, because I think a lot of people know Paul Bernardo has something called a dangerous offender designation. Why? How do you get a designation like that? How does that interact with statutory release or parole? What do you have to look like to get that designation, and what does it mean once you get it? Ari, that's for you.
Sure. So this is a really important part of the Sanderson story, and it's not talked about enough because Howard and I think, would agree that all fingers can't be pointed at the parole board or correctional services here. There's a problem in the prosecutorial office with regards to Mr. Sanderson, and nobody's calling it out. They knew he was a ticking time bomb, but we operate in a two-tiered system of law where, depending on your race, depending on your religion, depending on whether you're of Indigenous background, the criminal justice system is making a move to treat certain races and religions differently. That's a subject for a different day, but it factors in here. Why? Because the prosecution office where this happened knew, not just the parole board, but knew many years before that Myles Sanderson was vicious, a ticking time bomb to women and children, leaving aside the butchery he did. If they would have simply applied, and I will do this briefly, there's a lot to it, but it can be summed up as follows. If you think somebody's risk cannot be managed safely in the community, that's sort of like the movie Minority Report with Tom Cruise, that you can see the future crime happening. You can bring an application to a judge where that person may receive a very different sentence, either indeterminate essentially the rest of their life in jail, long term with very intense supervision. And that's all to keep the public safe when you're dealing with a fellow who, as I said, is a ticking time bomb. That wasn't done here. It's something that should be explored. And I think the prosecution offices in that province have more explaining to do than they have so far.
We've got to go to break, but we'll be right back.